Hi, I'm Randy Picker, obviously. And we're having a few technical difficulties today. If nothing else, we'll see if anyone shows up live. Emily is in California, talking to the world of online education. So she is not here, and John and I think, are struggling a little bit with the technology in her absence. But we will just see what happens here. John is off screen paying attention to his computer while I am staring into my computer. Speaking of online education, as you may have seen, there was an article on Coursera in today's Wall Street Journal. So if you're interested in what's happening in that platform space, and that's obviously the right way to talk about Coursera as a kind of platform. Some interesting stuff they're doing there, where they're really trying to roll out courses that are connected pretty directly to particular firms, doing that in conjunction with them. Rich Levin, who had been the Yale CEO, president, is now the CEO of Coursera, and so he talks through some of that there. I take it the other really interesting news this week in our space was Alphabet. The announced reorganization yesterday of Google, where Google now will, I have not looked at this, so a few viewers are rolling in, maybe the new link is rolling out, that's good. The new organizational structure for Google, which I have not looked at it carefully yet. My understanding is that shares in existing Google will roll over to Alphabet. I saw a story saying that because of the voting structure of different classes of shares of Google, that Page and Brin control something like 54% of actually the votes. And none of this changes their control over the company. And their control over the company means they have pretty broad flexibility in what they're doing. And I read a couple stories on this. There was an initial, burst briefly that this was somehow antitrust related. As if there was a question about that on the public non-alumni layer version of this course. I don't know EU law that well, so I'll be careful, but boy, I'd be surprised if it would work that way. The idea that you could, when the European Union fines companies, they do it based upon what they call turnover, so revenues, as it were, and the idea that you could, in some sense, reconfigure your way out of a penalty for prior acts, inconceivable that a sophisticated legal system would work that way. And I did read a statement today from someone at the EU saying, no, it doesn't work that way. So I don't think it's that. I did see the idea expressed that it could matter on a going forward basis. I could imagine that. And so if you are Google and you have a planned future of antitrust violations and want to structure as in anticipation of that, okay, is that what they're doing? I don't know. It seemed much more driven by the idea of providing greater transparency on some of their moonshot ventures as they talk about those. The one thing that I saw that was interesting was a question of exactly how Google allocates information internally at the firm. That's been one of the controversial issues, is as to what extent when Google is as it were amassing a dossier on me, that dossier includes information across products. And I did see the possibility that this might have consequences for that, but I will say I have not looked at that carefully. So Alphabet as an interesting development. On a much more local level, as I posted that you may not have seen on the discussion list today, this course is now approved for Illinois CLE credit. Oh, that was a loud cheer I heard from somewhere. That is something someone had asked about. Certainly something I'm interested in as the person who has created the course. And now Marjorie Holm here, who's done that, she and I sat down, I guess, Monday and played through the forms, and I think that approval came through as of today. So we will have to figure out the exact mechanism for that. And I think it'll cost $20 or something like that, because Illinois is now charging CLE providers when they provide credit, even if you're doing it for free. For those of you, I've talked to a number of people who said, I was going to say, they said they love the course. It would be even better if I could get CLE credit for it. Yeah, I hope the first part is true, and the second part I completely get. And I think that's where we are. So just Illinois. So look for the discussion link on that on the Canvas site, and maybe put your name up there, or send me an email if that's you think something you're interested in, and we'll sort through the exact mechanism on that. Okay. So we talk about where we are. We had two discussion topics running on sort of a combined net neutrality smartphones topics, and then we had the open questions, and there was a one, I think, that there from before, two really, but one I answered offline already. Three, I guess, and one I answered. So and John, who you was off screen, and better dressed than usual. We should almost have John come on screen. He is in the middle of interviewing, so looks suitably chic in a way that I simply do not. Yes, exactly. He's actually sort of manning the chat window, and he will report back on that in just a second. So the discussion topics really, Doug Anderson, my former student, hi Doug, and Stephen Shandor were sort of active on those. The one question I raised was basically the idea of, to what extent should we bring a neutrality regime, if you like to think in those terms, to other aspects of online life? That's sort of writ large is the question. It's pretty easy. I started to write a paper once sort of called Blank Neutrality, where it's pretty straightforward to say, what are the things that you might think neutrality should apply to? This vision of non-discrimination. And non-discrimination, as we talk about in the course, is one of the oldest idea in regulated industries. Really very much an important part of the Interstate Commerce Act of 1887, and basically roll forward from there. So it's a natural idea to have. The Google situation sometimes gets talked about as a question of search neutrality. Obviously, the net neutrality is a huge issue and a highly currently undergoing litigation in the United States based on the 2015 FCC rules that you looked at. It's a natural enough question. Indeed, I think a good thought exercise to say, well, to what extent should we apply those ideas to the smartphone space? You can see very clearly the non-neutralities in that system, and I sort of highlighted those in the question. It's Sinclair Kozoff. Is that who asked the question? Do you see? Can you go to the pre-populated questions? John's going there. I think it's Sinclair. As Sinclair noted, the Apple ecosystem is highly vertically integrated, and it is Sinclair. Thank you. Highly vertically integrated, and so the preferences that Apple gets for its products are dramatic, and the way in which Apple blocks other products is quite dramatic. And some of that's, it's very much it was a vision of what Steve Jobs thought was appropriate. They do that so highly non-neutral, I guess is what I want to say. And the question is, do you say, well, should we bring that to bear? So Doug, you know, and you can look at what Doug wrote, but Doug wrote what I would have expected he would have wrote. He said, look, my perfectly predictable answer, the printout in my hands, there should be no special legal principles that constrain the behavior makers of cell phones or operating systems for cell phones. Questions, do we see any meaningful harms here? And how do we identify those? And then questions of to what extent we think the government could do better. I do think that the Android investigation in the European Union is an effort to do that, at least through the tools of antitrust. It's obviously not about bringing a direct neutrality regime to bear on Android, not at all. I'm sure they would say much more traditional questions of contracts. So Sinclair's question on the pre-populated questions was sort of, why are they chasing Google and not chasing Apple? And I will say I've always found it interesting how little antitrust attention Apple in some sense has received. Now, obviously, the ebook case is a huge antitrust loss for them, and you almost certainly aren't that far in the materials, but you will get there. But that was to some extent self-inflicted. That was very much a situation where it was about joint activity and something which you could frame in terms of Section 1 of the Sherman Act pretty straightforwardly. It's a complicated case, I think, but you could easily do that. In contrast, when you simply have a single firm acting, we are much less willing to intrude into the activities of that firm as such. And that's an important gap between what we do under Section 1 and Section 2, and even seemingly a gap between what the EU does under, you know, Article 101 and Article 102. You know, the lever in the Android case are these contracts that Google is entering into, and I think that's what provides the window in there that you know, you just otherwise might not see. Steve Shander's post on this question of as it were smartphone neutrality. It's interesting. He talks about you know, the Apple cult, as it were. He puts that in quotes, so he's careful about that. He fully confesses that he is a multi-device Apple user. And then the question is there anything that we think that is going on there that we should regard as troubling? I guess my reaction to that is I'll say no. I mean, the notion that Apple is able to sell very expensive products to what I take it are on the whole well-to-do consumers, and certainly when you look at the demographics of Apple versus of iPhone versus Android, and I am an Android customer, just so we're clear. When you look at the demographics there, Apple's clearly hitting a premium market. That's what the prices you would expect, but that's what the data say as well. You know, there's nothing. I mean, if I'm able to convince you that this pen, which is an ordinary $1 pen, is really something that you should value for $10, my guess is we're probably not going to regulate that. I do think there are a few people out there who want to control the ability of firms to either shape products or shape the values that people associate with products. But that's a path I suspect we're unlikely to go down anytime soon. The second topic for the week was the question about the FCC's choices in the 2015 order. And Doug Anderson starts with a reference to Orwell's 1984, which I take it suggests he's not a big fan of the 2015 order. That is not what that's sort of what I expected. There's, I think, a strong, I'll say, conservative position, which is pretty hostile to net neutrality. I'm trying to figure out whether I'm going to do a debate on this with some people in January and at a Federal Society event. And I just think, you know, my own understanding of this I shouldn't tell you this after you've watched me talk about it for 3 hours, is too weak. I'm still sorting through it, I guess. And then Steve Shandor talks about, and now he's closer to Doug Anderson on this, still talks about the fact that prioritization is something we typically allow in the economy, and we're losing that through the FCC's 2015 order. I thought that was, I'm not a politician, so I don't think I understand political issues particularly well. It was very interesting that Tom Wheeler, who's the chair of the FCC, seemingly floated this idea of paid prioritization, and then backed away from that pretty quickly. And I think of the chairperson of the FCC as fundamentally being someone who's supposed to be pretty politically in tune. And so I would have assumed he would have floated that only after he had a pretty good handle on where that was, and not just sort of, oh, this would be an interesting idea, let's see what the world thinks about it. Academics do that. I don't think politicians do that for a living. So the fact that he floated that and then got what he seemed to regard as almost an unexpected response, maybe there's just a political dynamic there that I don't quite follow. We have a link on the blog. We have a link in the course to a blog post I did, which talks through some of the basic stuff on paid prioritization, and lots of reasons to think that's something we should want, and that's sort of what Steve Shandor says in his post. Okay, there was one question, and maybe we'll ask John to repeat the question. There was a Chevron deference question. You see that one? So John, remind us of what the Chevron deference question was.
All right, it's from Chan Stroman.
Okay.
I'm interested in your thoughts about the future of Chevron deference and the implication for regulatory authority if the doctrine is weakened or struck down. Relevant to the FCC, of course, but implications would broadly affect all administrative agency authority, correct?
Yeah, okay, so that's interesting. So one of the great joys of working at the University of Chicago Law School is our practice of having a table at the faculty club, the Quad Club, on Monday, Wednesdays, and Fridays. In olden days, we did that on Saturdays too, but I think we've gotten soft or something, because I don't know that we have a table there on Saturdays anymore. And the Quad Club, as you may know, is the building that is described as being the most important building on campus. Why is it the most important building on campus? Because that's where the education of the faculty takes place. And there's something to be said for that. So we have lunch Monday, Wednesday, Friday. Very few people go all 3 days. I try to go once a week and don't always succeed in meeting that. But in the summer, I do. And we actually ended up with 2 tables on Monday. We can only get like 13 in an actual round table, and 6 of us were at a square table. And we have a bit of a discussion about Chevron then. If you're following this closely, the FTC seemingly is getting ready to float, maybe not float, maybe announce guidance on their unfair methods of competition authority. So there was an article in the Wall Street Journal on this Monday. Wilson can post a link, but it almost certainly is behind a paywall, but we'll find some other link for that. And that would be interesting because the unfair method of competition authority is not well specified. And so the group of us at the smaller table talked through some of that Monday at lunch. But the question of Chevron came up too. And Aziz Haq was there, one of my colleagues, and Richard Epstein, both of whom are much more attuned to the administrative law issues than I am. And Richard and I were talking about Chevron on the way back and then in the elevator. I had the sense, I will say, and I learn a lot at lunch, but how much is the question? I had the sense that we were seeing the Supreme Court chipping away at Chevron a little bit. And that there was, we're past peak Chevron maybe. Richard wasn't, I don't misquote Richard, and Richard, so I don't misquote Richard. I think Richard wasn't sure that was true. That there was more change going on, more churn. So the Chevron doctrine was there was stuff going on there, but I don't think he thought it was necessarily one directional. I guess that's that sounded like a pop music reference, which I can assure you it was not. But there was just more stuff going on there. So now your question, Chan, is sort of, well, what would it do? I mean, you know, I'll say I don't know. Here's what I mean by that. So part of this has to be sort of a static versus dynamic perspective. So in a world in which you've got a particular statute on the books, Chevron obviously gives agencies enormous authority with regard to interpreting that statute. So for a given statute, then if you say, well, you cut back on Chevron deference, then it sounds like you're shifting authority back from the agencies towards the courts, right? That seems pretty plain vanilla. Now, if you go dynamic, then the dynamic thing you have to address is do you say, well, okay, but statutes are being drafted with reference to the scope of agency authority that they will have, and not just the authority on paper, but the authority in a world in which Chevron gives them a lot of room to operate. So are statutes more tightly drafted in an effort to control what would otherwise be a rule? I have no idea, right? But you see where all that goes. So it's not merely focusing on what cutting back on Chevron would do vis-a-vis the agencies, but it's also understanding the dynamic process of what that means for statutory drafting. But in the short run, for fixed statutes, it sounds like it would, you know, as it were, constrain a little bit the world of agency. I mean, Richard and I ended up talking about the APA on the way back from lunch, which I hadn't realized really had come into place in 1946. We were talking about sort of the Federal Trade Commission Act is amended in 1938 in interesting ways. So the 1914 statute is just the unfair methods of competition. The 38 amendment adds the undeceptive acts or practices or unfair acts or practices. And there's just an enormous amount. I'm working on this antitrust casebook with Diane Wood and Doug Melamed and Phil Weiser. We had meetings last week on Thursday and Friday, and we were talking through sort of that era from an antitrust standpoint. It's a really interesting time. All right, are there other questions?
Sure. Chan continued along those lines. I'm also curious about your thoughts on how actions of an agency might undercut its own arguments in favor of Chevron deference. For example, when the agency expressly states that an interpretation is inconsistent with or contradictory to a prior interpretation stated by the agency, or when the agency takes enforcement actions in a manner that is contrary to its own prior interpretation. Yeah, so I'll say there is, we're beyond what I will say I know about this. I know that there have been Supreme Court cases on this, and I'm trying to recall if Brand X is one of those. And we talked about Brand X a little bit Monday at lunch. But I'll say I think that's a doctrinal question with a doctrinal answer, and not one that I think I know the answer to. So I will not pretend to know the answer. Okay. Anything else? There was a question posted by Eric Hendricks. Okay. It's longer. Would you like me to read it, or he's gonna flip the computer around to me? Could the treatment of broadband ISPs have contributed to the demise of AOL insofar as access to the AOL platform as previously via dial-up, a common carrier infrastructure? With broadband, consumers could not access AOL without first buying access to the whole internet from the owner of the broadband infrastructure because it was not treated as a common carrier. For example, the consumer who subscribed to a telephone landline could freely use that line to access the internet via AOL, but the consumer who subscribed to television programming via cable could not use that cable to access the internet via AOL, but had to use. So I'll say I think the answer to that's probably yes. There's no question that we've seen if you look at conditions imposed in merger deals. Part of what they have tried to do in some of those, and these are typically deals that are being evaluated. I'm talking about in the communication space, and cable in particular, and those deals are being evaluated. Typically, it's a dual level filter, so the FCC is doing something, and then either the FTC or DOJ, but I think typically the FTC, they sort of allocate fields between them.
trying to preserve a kind of neutrality. What other word would I use? Trying to preserve a kind of neutrality with regard to these broadband pipes and not allowing the broadband pipe owners to distort that competition with regard to ISP services and the like is part of what they've tried to do there. Not necessarily successfully, I guess. So I'll say I'm not sure I know the answer to that question, but I think the answer is quite plausible. I don't know the AOL story very well, so I just ordered a book on Sun Microsystems yesterday because it's interesting the histories you think you ought to know and don't. I've been thinking about Java the last couple of days for a different project. The Google Oracle case, for those of you who followed that at all. I don't understand Java very well, and I don't know the AOL history particularly well, I don't think.
Okay, we've got a few comments in the Google Plus window.
Please, go ahead.
So Jerry Hellman says, if there's a naturally grown monopoly, when, if ever, would it become an essential facility?
Well, that's interesting. So we talked a little bit about essential facilities in Denver Thursday and Friday. And certainly someone, there were only 5 of us in the room. So someone said, oh, I think Trinco killed off essential facilities and sort of, and Trinco, John can post a link to Trinco, but Trinco's a Supreme Court antitrust decision in the intersection of a telecom space and antitrust, where the court declined to impose Aspen skiing-like mandatory dealing obligations in the context of telecommunications. And someone said Friday, oh, that's effectively an overruling of Otter Tail and a killing off of the essential facilities doctrine. I'm not sure about that. So the Supreme Court's been very proud of the fact, but they've never admitted to having an essential facilities doctrine. So how do they kill it off? And Trinco's pretty specific to the telecommunications industry, and the fact that the 96 Act had these encompassing mandatory dealing obligations made it fairly easy for the court to say, we're not going to do Aspen here. So then this question of, when does it become an essential facility? I'll say under antitrust proper, I think we've seen not that many cases like that. I mean, people talk about Aspen that way. I think there's a footnote in Aspen which expressly says they're not using an essential facilities analysis. We'd have to go look. It's very much a function of the course of dealing between the parties in that situation. The EU, I think, would not say that they're doing an essential facilities framing in Google search, the current pending investigation. I don't think they think of that. Do they think of that as a tying case? Maybe. As an abusive dominance case? Maybe. Essential facilities? I don't know if they're going to say that. Though if you ask, well, how behaviorally are they treating it in a way that differs from that? Maybe not a lot. So there's certainly a labeling issue there if there's not an issue in reality. Please.
Again from Jerry.
Yeah.
Could the separate subsidiaries of Alphabet in the future be found to have improperly combined or conspired with each other in violation of the Sherman Act that wouldn't have been complained against if they'd remained as a single corporate entity?
Well, so I'll say I think the natural doctrinal answer to that is no, right? So I'll be careful and say I don't know that we know what the case law on that says. I've never gone to look. Certainly what Copperweld effectively says, Copperweld is the case on this. What Copperweld effectively says is that a parent and a wholly owned subsidiary cannot for Section 1 purposes conspire. The logic of that is they are not separate economic decision-making centers, therefore they can't conspire. That framing of sort of separate economic decision-making centers is the framing that Justice Stevens uses in the American Needle case, which is the NFL properties case, where he says, okay, we will treat NFL properties, even though it's nominally a single entity, as subject to being, that they could conspire together, treated as being subject to Section 1. So I think the logic of those positions is to say no, that Alphabet shouldn't be within Section 1, or the subs, as you put it, shouldn't be within Section 1 merely because we have different entities. I think that's consistent with the analysis in Copperweld and American Needle. So I think that's what I think is the answer.
Okay. We have another, more of a comment from Jerry.
Sure.
Tim Wu, Columbia Law School.
My friend, Tim. I love Tim.
Seems to be both an academic and a politician. He's credited with having invented or at least promulgated the concept of network neutrality.
So is there? That was just a comment.
Just a comment.
Yeah. So Tim is legitimately both. For those of you who have followed these things, Tim and I co-taught. He visited here once, and we co-taught a seminar together. We had a great time. So I like Tim enormously. Smart, lively guy. Love talking to Tim. He is both a Columbia professor, but he also ran in the Democratic primary for lieutenant governor. And Zephyr Teachout, who I think is a Fordham Law School professor, was the governor candidate. Tim was the lieutenant governor candidate, and they ran against Cuomo and whoever is the lieutenant governor of New York. They did about as well as you would have expected academics to do. No, I don't know what to make of that. As you know, there's been something of a boomlet in law professors running for political offices. This fellow Obama seems to have done that with some effect. And I got emails in the last week saying that Larry Lessig, my former colleague here, has announced some sort of candidacy for the presidency. So Google Lessig 2016, and you can see what that is. So I will say I find being a law professor a full-time job. I am not likely to run for governor, lieutenant governor, or the presidency. Anything else?
Yes, we had another comment.
Sure.
From Bob Taylor.
Sure. Hi, Bob.
Posted about 8 minutes ago. Even the government provides prioritized services. Global entry for passports is just one of many examples.
Yes, absolutely. So exactly right. Now, yeah, there's no question that's right. There's sort of a fast lane approach sometimes at the FDA. Some of that's controversial, but there's no question that's right. And as I say, I do what I do. I create little models sometimes to understand things, and you work through that model, and you can see why everyone benefits. It's not just that the people who like faster service benefit, because what you're doing when you're having these types of priority services typically is you're often allocating a disproportionate share of the fixed cost of running these services to people who have, as it were, more intense valuations, who attach a higher value. And so there's a cost distribution feature to prioritization, which one should find attractive. Yeah, I think to try the other side of it for a second, I still. We shot the net neutrality videos last. I mean, we shot some of them. We shot the post office piece of it early, and then did the net neutrality proper at the very end because I wanted as much time to think about it as I absolutely could have. I think what people worry about is manipulation of capacity, and the incentives for doing that when you've got tiers of service, and then the question of whether those capacity choices are transparent or not. And so that I think is what maybe people are nervous about. I need to think about that more. That's the fair thing to say. I said what I said on net neutrality in the videos. On the one hand, this has been a remarkable growth of the internet. We've basically had no rules, and there have been very few problems. So why do we need anything, you might say, right? I completely get why someone might say that. On the other hand, the fact is there's been very little discrimination, and if all of a sudden firms act like they want to discriminate, and certainly some of the big telecom firms have occasionally made noises like that, then the question is, how does that change the ecosystem, and does that, the pressure that can put on innovation and not do that in a visible way? I think that's the counterweight, I guess.
No further questions.
No further questions. No further comments. Okay, that's good. That's fine. Then that's fine. So I think we have another one of these scheduled. We'll have to look at the schedule exactly. I am out of town next week, a family vacation to Toronto. So, and it's not inconceivable. I understand they have telecommunications in Toronto. So it's not inconceivable we could do one of these. I could imagine there would be a family preference for not doing one. And I just, I just live there. So, okay, thanks.